First one today, State versus Taylor Allen Aughenbaugh. I hope I'm pronouncing that right. It's case number CR 10-24-1447. Mr. Malik is here and Mr. Neal. Let's first address the preliminary hearing. Parties ready to go today, or do you need more time? I'm guessing on this one you might need more time, but I just want to...
Your Honor, I think additional time is prudent. Obviously, I'd be happy to do that if my client has a shot at getting out. I filed a motion to reduce bond. Discussed it briefly with the state. I don't know what their position is on that, but I think moving forward today is probably not the cards.
That then would need a waiver of time if we're going beyond this. This would be the first preliminary hearing, so have you addressed that with your client?
I have, Your Honor.
All right. Why don't you ask him some questions along those lines and see on the record if he understands his right to have his preliminary hearing within 14 days where he's in custody. Need to place that on the record, so if you want to ask him out loud.
Okay. Yes, Your Honor. Judge, do you understand that you have a right to have your preliminary hearing within 14 days?
Yes, sir.
All right. And you understand that you have a right to a preliminary hearing?
Yes, sir.
Okay. Do you understand that we are not waiving your preliminary hearing today?
Yeah.
And that we're just going to waive the statutory time frame to have the preliminary hearing in order to gather more evidence?
I do.
Is that sufficient, Your Honor?
Yes, so because you're in custody, it would be 14 days. Out of custody would be 21 days. Be how quickly that would need to be held from the time of the initial appearance. So if you're willing to waive that time frame, we can set this out at the date and time that the party will be ready to proceed. So Mr. Aughenbaugh, you understand that?
Yes, sir.
Okay, you are in fact then waiving the time frame, but not the preliminary hearing itself.
Right.
All right. Well, let's figure out a time that is going to work for everybody. And also, let me just ask, how long do you anticipate this hearing would be, and do we need to set it on a special day of its own? Is this one that is going to be, can it be done? It's possible we could get senior coverage if we set it on another day to take care of the other preliminary hearings, as I'm the magistrate assigned to this case. So,
I guess my first question is if the state has an expectation on when they'll receive ballistics and some of the other scientific evidence on the case.
I'm thinking that's probably going to take beyond what we would normally do as far as a reset. But yeah, in this particular case, I wouldn't think that it would be more than 2 hours for the state's case on probable cause.
you say more than the typical continuance, you're talking more than essentially 2 weeks, because that would be a typical time frame that we continue, but considering the nature of the charges and the circumstances here, how much time are you actually looking at?
The state doesn't have an objection to the 2-week
Do
continuance.
you think that would be enough time to be ready?
We're ready. I mean, I think the issue on where we would be as far as any technical testing, something that could come back from the state labs. You know, I'll discuss that with counsel a little bit, but I think that's likely to put us way down the road. So maybe what we do is just set up for a status in 2 weeks and see, or let's set up for a prelim, and then we can discuss amongst counsel if we're going to try to put this out any further, or just go with what we have.
No objection to an 8 March setting, Your Honor.
It's not one of my days. It needs to be So, although I don't think we have anything else that day, do we? We actually have the entire day. If we go 9 in the morning, does that work on a Friday?
Yes, Your Honor.
Is that the 8th?
It is the 8th.
Yeah, that'd be fine.
Continue this matter until March 8th at 9 o'clock. Now we'll address the other motion. So the motion to reduce bond was filed, it's like yesterday. Go ahead, Mr. Malik, if you want to follow the motion.
Thank you, Your Honor. Obviously, I have not pre-negotiated a reduction in bond with the state in conjunction with the continuance, but I guess throw myself on their mercy and compassion and say that in continuing this out, we're giving up substantive rights, and neither side is prepared to go given the state of the investigation evidence at this point. So. I think that should redound somewhat to the benefit of my client. We're not asking for no bond, but a reduction that would allow him even the opportunity to bond out would be much appreciated in light of the fact that we're continuing the preliminary hearing and giving up the right to have that hearing within 14 days.
Mr. Mann.
Under Rule 46, I think that the factor that is of gravest concern to the court is just the nature of the circumstances here. There was an individual that was shot in the leg, and there was an individual that was shot in the back. That shot went through his chest. Both, fortunately, are recovering from those injuries. But this particular melee involving the defendant did result in another weapon being used. We have an individual that was run over by a vehicle. So given the circumstances of this particular case, I think that the amount that the bond was set at originally should not be disturbed. And so we would ask the court to leave that at the $100,000 mark.
Give the last word.
Thank you, Your Honor. To be clear, I think I have no evidence that it was my client driving the vehicle. In fact, I have nothing I can put in front of the court right now, but I do not believe it was my client driving the vehicle that ran somebody over.
I can state unequivocally that's not what the state was trying to suggest. So,
I'm not even sure that the evidence will point to my client being the individual who shot another individual in the leg and through the chest. So, absent that evidence, again, I believe those facts should redound to my client's benefit. Thank you, Your Honor.
All right, well, at this point, all I have to go on is the affidavit of probable cause, which certainly does allege some serious charges here. The court looks at Rule 46 of the Idaho Rules of Criminal, or the Idaho Criminal Rules. 46 subsection C goes through the factors the court is to consider. I haven't heard anything as far as the first factor regarding employment status, history, or financial condition. So even at this point, I don't know if Mr. Aughenbaugh is employed. I also don't know what amount of bond would be that he could bond out on, so I don't have anything to go there. Number two, the nature and extent of defendant's family relationships. I have no information on that factor. Defendant's past and present residences. I don't have much there except for looking at, it's the criminal history report and interview summary from pretrial services. And that would at least show some prior juvenile matters, and they were all in Bonneville County, 2020 to 2023. So that's about all I've got as far as his residence goes. Apparently Bonneville County over the last few years. Defendant's character and reputation, I know nothing about that. Number 5 is the persons who agree to assist the defendant in attending court at the proper time. I have no information whatsoever on that. Number 6, the nature of the current charge and any mitigating or aggravating factors that may bear on the likelihood of conviction and the possible penalty. As far as that goes, I do have before me 2 aggravated battery charges with enhancements for use of a deadly weapon. So the nature of the current charges are certainly very severe. As far as mitigating or aggravating factors, I don't know about any mitigating, but as far as aggravating, that is essentially the weapons enhancement, those the court considers. As far as likelihood of conviction, the possible penalty, well, possible penalties, I believe, are per charge 15 years on count 1 and count 2 plus I believe another 15 years per count. So we're looking grand total of, well, per count 30 years, and if it was consecutive, you'd be looking at 60 years. So those are at least the possible penalties there. That's what the court is to consider as possible penalties. I don't know that would happen if there were convictions or not, but those are at least possibilities. 60 years is certainly a long time and something for the court to consider as far as the factors go. The defendant's prior criminal record is the next factor. It says, if any, and if defendant has previously been released pending a trial or hearing, whether defendant appeared as required. This is Mr. Aughenbaugh's first criminal case. It does have numerous juvenile matters. So don't really have a history as far as failures to appear on criminal charges. But at least as far as considering prior record, I do at least see those juvenile matters, and those at least weigh somewhat in the court's decision here. Number 8, any facts indicating the possibility of violations of law if defendant is released without restrictions. Well, I don't know, again, about that. Certainly there's possibility, but not really much information provided to me on that. Any other facts tending to indicate the defendant has strong ties to the community and is not likely to flee the jurisdiction. And not much information here other than that it appears Mr. Aughenbaugh has resided in Bonneville County since at least 2020. But again, he's facing potentially up to 60 years in prison, so whether that makes it that he's likely to flee the jurisdiction, I don't know. That's something to consider. And number 10 is what reasonable restrictions, conditions, and prohibitions should be placed on defendant's activities, movements, associations, and residences if I were to release him. Of course, the court could do some sort of thing like taking my passport and perhaps an ankle monitor. I think the jail is not wanting to do ankle monitors pre-conviction, typically. That would be something the court could consider. As I weigh all of those factors, at least the ones that I have information on, I find that $100,000 is a reasonable amount of bail, and I'm leaving it where it's at. So the motion is denied. All right. With that, I believe that's all we need to do on this matter today.
Nothing further from the defense, Your Honor.
We got nothing.
Thank you.
Right, take up the case of State versus Gabriel Perkins, case number CR 10-24-1448. Time and place for a preliminary hearing. Parties appear to be present, and represented by counsel. So what is the status of this case?
Your Honor, it's my understanding that we have an agreement, at least I think, to continue. I'm not sure if the stipulation's been filed or not. So we'd ask the court to entertain that request. We think 2 weeks is probably sufficient from what I know right now. If things change, we'll update the court. We also filed a motion for release or bond reduction. We'd ask that that same motion be continued and just rescheduled with whenever we reset the preliminary hearing. Piggybacking off of what we heard earlier today from another individual's hearing, it sounds like the court would be available March 8th, but we would ask that this preliminary hearing not be held with that preliminary hearing. Mr. Perkins is more of a victim of Mr. Aughenbaugh than a co-defendant, so we feel it would be appropriate to have separate preliminary hearings. It would probably take 3 hours, 4 hours, so you probably want to set aside an afternoon. But that would be our request. We've also filed a written waiver of time, I believe, or we have one that is prepared and could be submitted. It hasn't been filed.
I don't see that in the file, but has it already been signed?
It has been signed, and we're ready to file that. I can have my assistant do that as soon as we're done here.
We don't have any objections to that, do
Well, say 3 or 4 hours. But if we start promptly at, say, 1 o'clock on March 8th, that gives us a full 4 hours as opposed to 1:30 or something like that. And may not be in this courtroom because other preliminary hearings will be going that day. Another judge has them. So we'll find it in the courtroom. Continue the matter then, based on the waiver that we'll see as soon as that gets filed, but that has been represented, that has been signed. That's just a waiver of time. Continue it for 2 weeks to March 8th. Start at 1 o'clock. And that's promptly at 1 o'clock as opposed to 1:30 or something. I don't actually see a motion. There was a motion for everybody, so we'll address that at that time.
Thank you, Your Honor.
I believe that's all. That concludes all of our hearings today.